supplier or customer or partner and ending up with some sort of $50,000 or $100,000 judgment. And combine that with another $25,000 to spend on attorney's fees, which would not be uncommon. And now think, could you tomorrow write a check for $75,000 and continue to operate your business? If not, that means you frequently face bet the company litigation. Litigation is a minefield for the unwary. And so what I want to spend the next few minutes doing is making you just a little bit more wary. Now, in law school, lawyers don't sit down and memorize all the laws. That would be impossible. What you're trained to do is spot issues so that you know what questions to ask and you know where to go look up the right answers. That's what we're going to try to talk about today, is learning how to spot issues. Because it's not the things that you don't know that will hurt you. What will really kill you are the things you don't know that you don't know. So for example, if you hire an employee, you probably know you got to pay some sort of unemployment tax. You might not know the details, but you know enough to call an accountant and get it figured out. What you might not know is something like the fact that there's something out there called the statute of frauds that says certain types of oral contracts are completely unenforceable. You might be working on a handshake deal and only come to later find that that is entirely unenforceable. And that's the sort of thing that will really blindside you. I've tried to organize these helpful hints in order to help you remember them along the lines of 3 different old sayings or cliches. The first is that the devil's in the details. What that means is read it before you sign it. It seems like simple advice, but it is commonly not followed. And that's understandable. In a practical context, you're going to, big deals and small, you're going to spend a lot of time maybe talking about them. At the end of the day, you're going to be handed some sort of contract or maybe a form. And it's lengthy, and in the context of just trying to get your business done for the day, it's not practical to take 20 minutes and sit down and read it. You got to sign it and be out the door. Think about the next time you rent a car, you get handed this form. You instead stand at the counter with 10 people in line behind you, say, wait a minute, I'm going to read this. Stand here at the counter for 15 minutes in complete silence. Okay, and then sign it. Maybe not. Okay? But if you're signing forms for your business, you need to read them. Because small print can make a big difference. In the small print of a contract, you might sign away, for instance, your right to a jury trial. That's not uncommon. You might sign a contract that says, if there's litigation about this contract and the other side wins, you have to pay for their lawyer. But the reverse is not true. If there's litigation and you win, they don't have to pay for your lawyer. You can sign a contract that says that. That's common. You might sign a contract with a receivership provision that says that if you break this contract, the other side can go to the court, get someone else appointed to run your business without telling you, and show up at your business one day with the sheriff and this person and tell you, step away from your counter, step away from your cash register, this person now runs your business until you get this debt paid. These are all things that can exist in the boilerplate of contracts, the fine print at the bottom, and that fine print can be key. So you need to read it before you sign it. All contracts are negotiable. So now some people might not be willing to negotiate your contract. They might say, this is the deal, take it or leave it, and that's up to them. But you should always feel comfortable asking, what does this mean? Can we change this provision? If they tell you, no, we can't change it, what they mean is they won't change it. And that's different. They certainly can change it. They have that ability. Any 2 contracting parties can do that. And that's why you need to read it before you sign it. And don't take this, I can't change it as an answer. That's not an answer. I won't change it. Okay, well now we're having a discussion about what you're willing to do and what you're not willing to do. But don't tell me you can't do it. That's just not true. Legally, you can do it if you choose to. The other thing, the other devil that's in the details is, do not adopt for yourself, boilerplate legal jargon that maybe just sounds good if you yourself don't understand it. And this is something that happens all the time. Some of my scariest moments dealing with clients are when they bring me their own contracts, their own corporate documents, for instance, their articles of incorporation, their partnership agreements, that sort of thing. And they say, oh, I, or my HR person, or my accountant found this online, or we had this in some other agreement, so we cut and pasted. Oh my God, those are terrifying words to me. We cut and pasted into this. I don't really know what it means. It sounded good. It seemed like we should have something here, and so we used it. Now, if you're going to, stitch something, a bunch of different pieces together and then try to breathe life into it as a contract, ask Dr. Frankenstein how that worked out. It's not a good deal, okay? And you're better off having no rules than you are having rules that you don't understand and you yourself don't follow. And that happens all the time. People will adopt, an article, an incorporation agreement or partnership agreement they find online, and they'll come bring it to me after their business breaks up and people are mad at each other, and I'll say like, well, this requires you to have 4 corporate officers. Did you ever do that? No, we never did that. You're supposed to have quarterly meetings and take minutes. Can I get the minutes from those meetings? We never had those meetings, all right? You're better off having no rules than you are having pristine rules that you've never followed. In the mind of the court, that's the difference between negligence and intentional misconduct, all right? Those same rules that seem like a good idea, unless you know them and you follow them, which is the best thing to do, having them and not following them is the worst thing to do. You're just hanging yourself with your own boilerplate, so please don't do that. Second, don't let sleeping dogs lie. Ignoring problems will not make them go away, I guarantee you, okay? And so you need to, when things come up, you need to deal with them promptly and effectively. And if you need help, get help, call sooner. As a practical matter, here's the easiest way to follow this rule. Get your mail and read it, all right? More and more we don't do that, right? Obviously, if something's important, it's not going to come to me in the mailbox. That's where junk mail goes. I'm going to get it electronically. I'm going to get an email. I'm going to get an electronic invoice, etc. That's largely true in business. It's not true under the law. Okay, the way you get served with legal process is through certified mail or with a process server coming and handing it to you. This is especially important if you're a business, rather than having mail delivered to a home or a place where you do business, you have a P.O. box. Maybe you check it once a week. Maybe you're busy that week, you're going to check it every 2 weeks. When things hit your mailbox, deadlines start to run. Your time starts to tick, and those deadlines are important. Once again, I often have clients come to me and say, oh yeah, here's this thing I got in the mail like 3 weeks ago. Can you take care of it for me? Well, sure. Your answer's due tomorrow, all right? And it's 3 o'clock today, and we need to figure out exactly, I have no idea what's going on. I've never heard of this. This is a lawsuit against you. I've never heard of it before. And now we're under a time crunch. Or worse yet, your answer was due last week, and they just went and got a default judgment against you, okay? Maybe, you might be stuck with that. Maybe I can go set it aside, but best case scenario, you're paying me a few $1,000s just to get you back to square one, just to undo everything that's been done while you were waiting. And that's not something you want. So deadlines start to run. For instance, you might get a garnishment in the mail. So you have an employee, this employee has not paid their child support, or they got a credit card, they haven't paid their credit card, Visa went and got a judgment against them, and so they've sent something to you that says, please garnish this employee's wages, take a percentage of them, and send them to me, rather than sending them to the employee. Now, when you get something official standing in the mail, I get it. It's confusing, it's pig Latin, it's intimidating, and just because all of us psychologically just don't want to deal with it, I'm going to put the bottom of my to-do pile. I have real business I really have to take care of today. This I just don't want to deal with. I'm going to deal with it later. Again, by letting something like a garnishment lie, you run a real risk. If you answer a garnishment, you're really not out any money. You have to send a check to one place instead of another place. But if you let the time run out and you don't answer a garnishment, you could be held liable for that other person's judgment. So if you want to go pay your employee's $10,000 Visa bill, Visa will come to you and say, I sent you a garnishment on this date, you didn't answer by this date. Under the rules, guess what? This is now a judgment against you. You owe me $10,000. These are situations you don't want to get into, and the way you avoid them is by asking questions early, getting help soon. And that's because, third, an ounce of prevention is worth a pound of cure. Look, I know we always hear about people being in a litigious society, and that might be true, but most people want to avoid litigation on both sides. If they can work it out, especially in the business context, without having to go to court, they will. And what forces a lot of people to go to court is the fact that they're making demands on somebody, and they're not getting any answers. They're getting ignored. No one's dealing with them, so they think the only way to get this person's attention is by suing them, and that's exactly what they'll do. So if you have these issues come up, call a lawyer. I understand you don't want to pay that money. I get that we're expensive. We are. But a lawyer is like a plumber. You want to call one too soon rather than too late. Because if you call a lawyer or a plumber too late, there's a good chance you're already up to your hips in significant problems. okay, that you don't want to have to deal with. So call us too early or too late. So how do I find one if you don't have one? I would say seek personal referrals, ask around, find somebody who has a lawyer they know and trust. That's important. You want a lawyer you can depend on. But you also want a lawyer who has some experience in the type of law you're dealing with. All right? The days when you had this sort of country general practitioner who wrote a will on Monday and did a land deal on Tuesday and defended the DWI on Wednesday are gone. The law is simply too complicated for that. So don't have the lawyer you went to get your trademark also, do your lease for your building and do your HR issues. That's probably not true. You probably need someone more. Now you can go to that first lawyer for a referral to somebody else, but you're probably not going to have the same person do everything. The KCMBA, the Kansas City Metropolitan Bar Association, is a lawyer referral service that I welcome you and encourage you to check out. And when you talk to lawyers, don't be afraid